Introduction of the study, nature, and extent of the laws of England. Introduction. Section the first. On the study of the law. Read in Oxford at the opening of the Vinerian Lectures, 25 October, 1758. All right, introduction, section the first, on the study of the law. Mr. Vice-Chancellor and gentlemen of the University, the general expectation of so numerous and respectable an audience, the novelty, and, I may add, the importance of the duty required from this chair, must unavoidably be productive of great diffidence and apprehensions in him who has the honor to be placed in it. He must be sensible how much will depend upon his conduct in the infancy of a study, which is now first adopted by public academical authority, which has generally been reputed, however unjustly, of a dry and unfruitful nature, and of which the theoretical, elementary parts have hitherto received a very moderate share of cultivation. He cannot but reflect that if either his plan of instruction be crude and injudicious, or the execution of it lame and superficial, it will cast a damp upon the farther progress of this most useful and most rational branch of learning, and may defeat for a time the public-spirited design of our wise and munificent benefactor. And this he must more especially dread when he feels by experience how unequal his abilities are, unassisted by preceding examples, to complete, in the manner he could wish, so extensive and arduous a task. Since he freely confesses that his former, more private attempts have fallen very short of his own ideas of perfection, and yet the candor he has already experienced, and this last transcendent mark of regard, his present nomination by the free and unanimous suffrage of a great and learned university, an honor to be ever remembered with the deepest and most affectionate gratitude. These testimonies of your public judgment must entirely supersede his own, and forbid him to believe himself totally insufficient for the labor, at least of this employment. One thing he will venture to hope for, and it certainly shall be his constant aim, by diligence and attention to atone for his other defects, esteeming that the best return which he can possibly make for your favorable opinion of his capacity will be his unwearied endeavors in some little degree to deserve it. The science thus committed to his charge to be cultivated, methodized, and explained in a course of academical lectures is that of the laws and constitution of our own country, a species of knowledge in which the gentlemen of England have been more remarkably deficient than those of all Europe besides. In most of the nations on the continent, where the civil or imperial law, under different modifications, is closely interwoven with the municipal laws of the land, no gentleman, or at least no scholar, thinks his education is completed till he has attended a course or two of lectures, both upon the institutes of Justinian and the local constitutions of his native soil, under the very eminent professors that abound in their several universities, and in the northern parts of our own island, where also the municipal laws are frequently connected with the civil. It is difficult to meet with a person of liberal education who is destitute of a competent knowledge in that science, which is to be the guardian of his natural rights and the rule of his civil conduct. Nor have the imperial laws been totally neglected even in the English nation. A general acquaintance with their decisions has ever been deservedly considered as no small accomplishment of a gentleman, and a fashion has prevailed, especially of late, to transport the growing hopes of this island to foreign universities in Switzerland, Germany, and Holland, which, though infinitely inferior to our own in every other consideration, have been looked upon as better nurseries of the civil, or which is nearly the same, of their own municipal law. In the meantime, it has been the peculiar lot of our admirable system of laws to be neglected, and even unknown by all but one practical profession, though built upon the soundest foundations and approved by the experience of ages. Far be it from me to derogate from the study of the civil law considered apart from any binding authority, as a collection of written reason. No man is more thoroughly persuaded of the general excellence of its rules and the usual equity of its decisions, nor is better convinced of its use as well as ornament to the scholar, the divine, the statesman, and even the common lawyer. But we must not carry our veneration so far as to sacrifice our Alfred and Edward to the manes of Theodosius and Justinian. We must not prefer the edict of the praetor or the rescript of the Roman emperor to our own immemorial customs, or the sanctions of an English parliament, unless we can also prefer the despotic monarchy of Rome and Byzantium, for whose meridians the former were calculated, to the free constitution of Britain, which the latter are adapted to perpetuate. Without detracting, therefore, from the real merit which abounds in the imperial law, I hope I may have leave to assert that if an Englishman must be ignorant of either the one or the other, he had better be a stranger to the Roman than the English institutions. For I think it an undeniable position that a competent knowledge of the laws of that society in which we live is the proper accomplishment of every gentleman and scholar, and highly useful, I had almost said essential, part of liberal and polite education. And in this I am warranted by the example of ancient Rome, where, as Cicero informs us, the very boys were obliged to learn the 12 tables by heart, as a carmen necessarium or indispensable lesson, to imprint in their tender minds an early knowledge of laws and constitution of their country. But as long and universal neglect of this study with us in England seems on some degrees to call in question the truth of this evident position, it shall therefore be the business of this introductory course, in the first place, to demonstrate the utility of some general acquaintance with the municipal law of the land, by pointing out its particular uses in all considerable situations of life. Some conjectures will then be offered with regard to the causes of neglecting this useful study, to which will be subjoined a few reflections on the peculiar propriety of reviving it in our own universities. And first, to demonstrate the utility of some acquaintance with the laws of the land, let us only reflect a moment on the singular frame and polity of that land which is governed by this system of laws. A land, perhaps, the only one in the universe, in which political or civil liberty is the very end and scope of the Constitution. This liberty, rightly understood, consists in the power of doing whatever the laws permit. 1. Which is only to be effected by a general conformity of all orders and degrees to those equitable rules of action, by which the meanest individual is protected from the insults and oppression of the greatest. As, therefore, every subject is interested in the preservation of the laws, it is incumbent upon every man to be acquainted with those, at least, with which he is immediately concerned, lest he incur the censure, as well as inconvenience, of living in society without knowing the obligations which it lays him under. And thus much may suffice for persons of inferior condition, who have neither time nor capacity to enlarge their views beyond that contracted sphere in which they are appointed to move. But those on whom nature and fortune have bestowed more abilities and greater leisure cannot be so easily excused. These advantages are given them, not for the benefit of themselves only, but also of the public, and yet they cannot, in any scene of life, discharge properly their duty either to the public or themselves without some degree of knowledge in the laws. To evince this the more clearly, it may not be amiss to descend to a few particulars. This note 1. This seems an imperfect definition of civil liberty, as it neither provides that the laws, which are to be the rule of conduct, should be just and equal, nor that the subject should have taken part in their enactment. Consistently with this, a slave on a sugar estate is free. He may do whatever the laws permit him to do. It is probable that the author had his eye on the definition of Montesquieu, which is still more incomplete. La liberté est le droit de faire tout ce que les lois permettent. ESPL 111c3. The passage cited from Justinian cannot, I think, have been intended for a definition of civil liberty. Liberfis quidem, ex qua etiani liberi vocanter, est naturalis facultas ejus quod suque facere libet nisi quid 6 aut jure prohibitor. This may describe a state of natural freedom well enough, which is the power of acting as we please, unrestrained either by force or law. But restraint by law is consistent with civil freedom. Locke's definition seems to supply what is wanting in those before mentioned. Freedom of men under government, says he, is to have a standing rule to live by, common to every one of that society, and made by the legislative power erected in it, a liberty to follow my own will in all things, where the rule prescribes not, and not to be subject to the inconstant, uncertain, unknown, arbitrary of another man. On Government, B2, Chapter 4. Let's see, this section had the title on the study. This section had the title of the law. Let us therefore begin with our gentlemen of independent estates and fortune, the most useful as well as considerable body of men in the nation, whom even to suppose ignorant in this branch of learning is treated by Mr. Locke as a strange absurdity. It is either landed property, with its long and voluminous train of descents and conveyances, settlements, entails, and encumbrances, that forms the most intricate and most extensive object of legal knowledge. The thorough comprehension of these, in all their minute distinctions, is, perhaps, too laborious a task for any but a lawyer by profession. Yet still the understanding of a few leading principles relating to estates and conveyancing may form some check and guard upon a gentleman's inferior agents, and preserve him at least from very gross and notorious imposition. Again, the policy of all laws has made some forms necessary in the wording of last wills and testaments, and more with regard to their attestation, and ignorance in these must always be of dangerous consequence. To such as by choice or necessity compile their own testaments without any technical assistance, those who have attended the courts of justice are the best witnesses of the confusion and distresses that are hereby, occasioned in families, and of the difficulties that arise in discerning the true meaning of the testator, or sometimes in discovering any meaning at all, so that in the end his estate may often be vested quite contrary to these his enigmatical intentions, because perhaps he has omitted one or two formal words which are necessary to ascertain the sense with indisputable legal precision, or has executed his will in the presence of witnesses than the law requires. But to proceed from private concerns to those of a more public consideration, all gentlemen of fortune are, in consequence of their property, liable to be called upon to establish the rights, to estimate the injuries, to weigh the accusations, and sometimes to dispose of the lives of their fellow subjects, by serving upon juries. In this situation they have frequently a right to decide, and that upon their oaths, questions of nice importance, in the solution of which some legal skill is requisite, especially where the law and the fact, as it often happens, are intimately blended together, and the general incapacity even of our best juries to do this with any tolerable propriety has greatly debased their authority, and has unavoidably thrown more power into the hands of the judges, to direct, control, and even reverse their verdicts, than perhaps the Constitution intended. But it is not as a juror only that the English gentleman is called upon to determine questions of right, and distribute justice to his fellow subjects. It is principally with this order of men that the commission of the peace is filled, and here a very ample field is open for a gentleman to exert his talents by maintaining good order in his neighborhood, by punishing the dissolute and idle, by protecting the peaceable and industrious, and above all by healing petty differences and vexatious prosecutions. But in order to attain ends, it is necessary that the magistrate should understand his business, and have not only the will, but which must be included in the knowledge of legal and effectual justice. Else, when he has mistaken his authority through passion, through ignorance, or absurdity, he will be the object of contempt from his inferiors, as of censure from those to whom he is accountable for his conduct. Yet, farther, most gentlemen of considerable property, at some period or other in their lives, are ambitious of representing their country in Parliament, and those who are ambitious of receiving so high a trust would also do well to remember its nature and importance. They are not thus honorably distinguished from the rest of their fellow subjects, merely that they may privilege their persons, their estates, or their domestics, that they may list under party banners, may grant or withhold supplies, may vote with or vote against a popular or unpopular administration. But upon considerations far more interesting and important, they are the guardians of the English Constitution, the makers, repealers, and interpreters of the English laws, delegated to watch, to check, and to avert every dangerous innovation, to propose, to adopt, and to cherish any solid and well-weighed improvement bound by every tie of nature, of honor, and of religion, to transmit that Constitution and those laws to their posterity, amended, if possible, at least without any derogation. And how unbecoming must it appear in a member of the legislature to vote for a new law, who is utterly ignorant of the old? What kind of interpretation can he be enabled to give, who is a stranger to the text upon which he comments? Indeed, it is perfectly amazing that there should be no other state of life, no other occupation, art, or science, in which some method of instruction is not looked upon as requisite, except only the science of legislation, the noblest and most difficult of any. Apprenticeships are held necessary to almost every art, commercial or mechanical. A long course of reading and study must form the divine, the physician, and the practical professor of the laws. But every man of superior fortune thinks himself born a legislator. Yet Tully was of a different opinion. It is necessary, says he, for a senator to be thoroughly acquainted with the Constitution. Declares, is a knowledge of the most extensive nature, a matter of science, of diligence, of reflection, without which no senator can possibly be fit for his office.